This is Dr. P. Kokila, Assistant Professor, Department of Commerce from St.Josephs College of Arts and Science for Women, Hosur. The Sale of Goods Act 1930, an act to define and amend the law relating to the sale of goods, whereas it is expedient to define and amend the law relating to the sale of goods. Meaning of goods. Goods means every kind of movable property other than actionable claims and money, and includes the following: stock and shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be served before sale or under the contract of sale. For example, old rare coins, stock, shares, debentures, goodwill, patents, trademark, copyright, water, gas, electricity, grass, growing crops, trees to be cut and their log wood delivered. It's called goods. What are the major things excluded from the term of goods? Actionable claim, money, immovable properties. Types of goods. First one is existing goods. In existing goods, specific goods, ascertained goods, and ascertained goods are there. Future goods and contingent goods. Let's talk about the types of goods in detail. Existing goods. Existing goods are such goods as are in existence at the time of the contract of sale, that is, those owned or possessed by the seller. Kinds of existing goods are specific goods, ascertained goods, and unascertained goods. What is meant by future goods? Future goods means goods to be manufactured or produced or acquired by the seller after making the contract of sale. Thus, under the Act, a contract of sale of future goods, for example, 1,000 quintals of potatoes to be grown on A's field, is not illegal, though the actual sale of future goods is not possible. This is an example of agreement to sell. Another example, X agrees to sell to Y all the crops to be grown at his farm in Haryana during the year 2009 for a sum of rupees 1 lakh. This is an agreement to sell future goods and not a sale. What is contingent goods? Contingent goods means the goods, the acquisition of which by the seller depends upon non-happening of an uncertain event. For example, S agrees to sell 10 units of an article provided the ship which is bringing them reaches the port safely. Another example, S agrees to sell to Y all the crops to be grown at Z's farm in Delhi during the season of 2009 for a sum of rupees 2 lakhs. If Z sells the same to X, this is an agreement to sell contingent goods because the availability of crops depends on its sales by Z. Specific goods means goods identified and agreed upon at the time a contract of sale is made. For example, a car, a table purchase. Ascertained goods. Goods identified subsequent to the formation of the contract of sale. The terms ascertained and specific are commonly used for the same kind of goods. For this goods, example, a TV shop owner agreed to sell B a particular model TV identified by the customer out of the several TVs on display. What is uncertain goods? Goods not identified at the time of making of the contract of sale. They are no definite and specific. They are goods defined by the description only. For example, A visited TV sales showroom and agrees to buy a TV out of the 50 models on display. The shop owner agrees to sell. This sale agreement is for unascertained goods as the specific TV is yet to be identified. What is price? Section 210 defines the price as the money consideration for the sale of goods. Price has to be in terms of money. What is delivery of goods? And the meaning of delivery of goods is voluntary transfer of possession from one person to another. The mode of delivery is by doing anything which the parties agree, and by doing anything which has the effect of putting the goods into buyer's possession. The following are the various types of delivery. Actual delivery, when goods are physically handed over to the buyer or his authorized agent. Symbolic delivery, where some symbol of the real possession or control over the goods is handed over to buyer. And finally, constructive delivery, where a person who is in possession of the goods acknowledges to hold the goods on behalf of the buyer. The following are the rules as to delivery. First one, payment and delivery to be concurrent. Mode of delivery, effect of part delivery, and buyer to apply for delivery. Place, time, and delivery when the goods are in possession of third party. Demand of delivery to be treated as ineffectual. Expenses of delivery and delivery of wrong quantity and delivery by installment. A seller of goods who has not been paid in full for them, or who has received a check or other negotiable instrument that has not been honored. Although ownership of the goods may have passed to the buyer, an unpaid seller has certain rights against the goods themselves. Unpaid seller rights, where property in goods has passed. Right of lien section 47 explains entitled to retain possession until payment under the following cases: where goods have been sold with effect of any stipulation as to credit, where goods have been sold on credit and the term has expired, where the buyer becomes insolvent and the seller is in possession of the goods. When US has made part delivery of goods, he may exercise right of lien on the remainder. Thank you very much.